challenge on a personal level, on a spiritual level, in trying not to close down to those people I so disagreed with and those people who were attacking me. And I don't know how well I did, but I'm still here, and I wanted to thank this organization so much for what you do and the lives that you touch. I have just been so impressed by meeting all of you, and I'm truly honored and blessed to be here, and I thank you so much for inviting me.
Actually, George is agreed to just answer some questions.
I would like to have just a short question for you regarding federal rights and state rights with the state Supreme Court with the drugs, and Oregon being the only state granting a person permission to choose being jeopardized now. The bottom line is I see state and federal rights. Do you have any comments on this case?
I can't speak with great depth about this because I'm not intimately familiar with the facts of the case, and so I want to be very careful about that. From what I do know from the news accounts, I see this as an issue of federalism, respect for state rights, and I think it's going to be a initial test for this new Roberts court, because his predecessor, Chief Justice Rehnquist, was one of the greatest proponents of federalism, respect for state rights. However, you see in every court the propensity for ideology to trump judicial principle. And so I'll be interested to see whether the judicial principle of federalism and respect for state rights wins over what we may suspect is an ideological bias against the Oregon law.
Why don't I moderate here? I'll make it easier than... yes, this gentleman right here.
I think your description of the permission to remove feeding tubes was only part one. I think that condemns a person to a death by comparison to which crucifixion is merciful. I want to go further. Instead of merely removing the tube, I would like a legal injection. What's the possibility of that?
Okay, to summarize the question, this gentleman believes that simply removing a feeding tube or removing nutrition and hydration does not go far enough. That, in essence, that when you make that decision, why shouldn't the patient be, shouldn't the patient's death be hastened at that point? And he mentioned a lethal injection.
I want to address the first part of your question, because it's something that we encountered so much in the debate about Schiavo. The description of Terri's death being horrific, barbaric. From all the medical evidence that I have seen, that I have read, that was introduced into court, from my practical experience as a hospice patient volunteer, all that I have seen leads to the conclusion that death which results from the removal of a feeding tube is a relatively painless death and easily managed by pain medication in those instances where medication is required. So I wanted to address that first. As to the second, I guess I'll take that in two parts as a lawyer and then personally. In arguing these cases, I've been extremely careful, and the courts in adjudicating cases to withdraw medical treatment are very careful to make the distinction of an act of medical choice which may let nature take its course, and the introduction of an agent, whether it was as publicized with carbon monoxide or injection with the intention of killing the patient. The courts have been very, very clear that one is legal and one is illegal. As far as the broader issue of the constitutionality of that, that was tested and rejected by the United States Supreme Court. So as a lawyer, that's my legal answer. From a personal level, I'm struck by the statistic that approximately 2/3 of Americans strongly agree that they should have the right to physician assistance for suicide. And from a personal point of view, in my hospice background, I think that's another indictment on the end-of-life care system, that so many patients receive such poor end-of-life care where suicide becomes an option for so many. I would like to see a system where that option rarely, if ever, appears, because the emotional, psychological, physical pain management needs of a patient are met. In those rare cases where, because of the particular illness of the patient, that it couldn't be met, whether that should be an option, it's not for me to judge. It's not for me to judge, or I'd like to see that left to the patient to make that decision. And I'll tell you if you hear the hesitancy in my voice, that might not be the decision that I'd want to make for myself. But one of the first things I learned as a hospice patient volunteer, and one of the hardest things I learned, was you're there to facilitate the death of the patient. Not the death that you envision you'd like to have for yourself, or the death that you think the patient ought to have, but the death of the patient. And that respect for the individual to make their own decisions carries a lot of weight with me.
Okay, so many questions right back here. Her statement when she's in training to be a long-term care ombudsman, and the question was, what should you say when someone asks you about assisted dying, or what can you do as a long-term care ombudsman? If someone did ask you about assisted dying, okay, well, I'm not sure George will feel comfortable answering this.
If someone asked me, I'd ask them to contact this organization, who is obviously knows the answers to those questions, but also knows the legal answers to those questions as well.
And just to answer the question, that is that we do provide information to people under certain circumstances and guidelines to help them hasten death with their physician's assistance, or a number of other choices like stopping eating and drinking, or the process of total or palliative sedation. And our case managers would work with the client one-on-one to kind of develop a plan. And it would all be legal and ethical and above board. The next question, way back there.
Did the Browning decisions apply federally or just to the state?
The question was, did the Browning decision apply federally or just to the state of Florida?
Grounding was issued by the Florida Supreme Court and in a strict legal sense applied only to the state of Florida. Its principles were cited by cases, by courts in other states as supportive precedent for their decisions. One thing that we have the benefit of in the state of Florida is that we have a constitutional guarantee of privacy in the state constitution that was passed in a constitutional amendment, which has served as a firm foundation for the court's decisions in this area.
How about over here? We've been favoring this side of the room a bit, so.
Yeah, at the outset, you made some reference to the difficulty in ascertaining truth in the case and the problem sometime with the media's accuracy. I think that maybe because of that, could you comment at all on the initial fact pattern? Because I think I was left with the feeling that there might be some real issues about the determination of Terri's intent in the case. And when your client first came in, you made it sound as though there really wasn't an issue there. Is it because of media that left me with the feeling that that was a continuing issue of determination of Terri's intent?
So the question and statement is that he was left with sort of conflicting views about what was actually happening to Terri Schiavo based on the media reports. And the question is as I think I understand it, is, well, it was to ask for a comment on the depiction of the case and sort of the reality versus the depiction of the case. Is that right?
Well, in terms of Terri's desires, was it as clear, factual as expressed?
Right. Okay, so it was the portrayal of Terri's desires in the case, what the facts were in the case versus sort of the media on the issue.
Terri's intent was established by the testimony of 3 witnesses. The first was her husband, who testified to approximately 3 or 4 conversations he had with her at different times. Now, these were conversations that were catalyzed by events in Terri's life. Her grandmother was on a respirator, and this was her maternal grandmother, and a decision was made to remove the respirator. And Terri made a statement like, I wouldn't want to be kept alive by artificial life support. Another conversation catalyzed by watching a news presentation on 60 Minutes or some other program where somebody's in a catastrophic condition, where she said to her husband, I don't want to be kept alive artificially. Promise me, please promise me that you won't keep me alive that way. Another conversation was catalyzed by an uncle whose primary caregiver died, who was needed care because of a stroke. And so the question came up, well, who's going to care for our uncle now? And in which she said, if I ever had to be dependent on the care of others, I wouldn't want to live that way. So these were the type of conversations that Terri made to her husband, which if you look at the real world of how people express their end-of-life preferences, it's usually in that contextual, informal way. The other witnesses, one was Mr. Schiavo's brother, who testified to a conversation with Terri at a funeral. And the third witness was her sister-in-law, Joan, in which she had 3 or 4 different conversations. There was one involved a mutual friend who had a young, an infant with a congenital defect, and an end-of-life treatment choice had to be made, in which Terri expressed the wish that she supported the parents' choice to let the child die and not subject it to surgery. A conversation precipitated by watching a diver who was in a diving accident and who had tubes coming out of him, and she said, no tubes for me. I don't want to have any tubes done. So these were the type of conversations from 3 witnesses. Now, the portrayal in the media was, oh, all we have is the testimony from a husband who's involved with another woman who can rely on that. There were 2 other witnesses, but it does, some of the reporting was correct as to the testimony of 3 witnesses, but those were referred to as casual conversations. Can we really make these type of momentous decisions based upon the offhand remarks made by somebody when they encounter a situation where it may come up? And I think it bears remembrance what Justice O'Connor said in her concurring opinion in the Cruzan case, because they were talking about Nancy Cruzan's comments to people which are of a very similar nature. And she said, Justice O'Connor said, that's how people talk about this. If we're not going to honor the oral directives of the patient made in this manner, then virtually the right to refuse medical treatment will be unenforceable. Because if you look at the statistics, back then less than 1 in 5 adults had living wills, and that's how people communicated their wishes. So, but that's the direct answer to your question. Let me give you the bigger answer. Because you had a trial judge in this situation listening to the testimony, and although that testimony was important to him, I think the bottom line in this case was he believed the husband and he didn't believe the parents. And that's how the evidence shook from the tree. That Mr. Schiavo, the first 3 years after Terri had her initial cardiac arrest and was in a vegetative condition, basically lived with her. Was with her every day. Accompanied her to every doctor's visit, which for a total care patient is not an easy thing, the ambulance, the transport, hundreds of doctor's visits. He looked into Michael Schiavo's eyes and believed what he said when he said, I love Terri. I love Terri, I'm trying to carry out her wish. And he also looked into the parents' eyes and the eyes of the siblings. And the testimony was, we had testimony of one healthcare worker who Michael hired to read to Terri and be with Terri almost on a daily basis for 2 years to try to see if he could generate some response. And she said, I saw the parents come in one day, and the nurse said, who are you? In other words, they visited so infrequently. They visited maybe once a month. The siblings maybe visited her once or twice a year before this case became the public relations spectacle that it did. Also, the parents' testimony was impeached 19 times by their deposition testimony. That means basically you testify under oath one way before trial, and then your story changes at trial. So I think in a human way, because judges are not these automatons, as Your Honor knows, I think the judge developed a certainty in his gut that Michael was the one who cared for her, continued to care for her, and loved her, and was on the level. And that, in conjunction with the other evidence, I think is the reason he ruled as he did.
We are just about out of time, I'm sorry. Okay, one more question.
Did it get paid? Not you, but transportation.
Oh, the question was, who was her care paid for by? Or how was her care paid for? Okay.
Terri's medical care, nursing home care, and hospice care was paid out of her guardianship fund until approximately 2002, when the funds, in essence, ran out. After that point, Hospice of the Florida Suncoast had her on their indigent care list, so they provided her care at the organization's expense. And Terri had also qualified for Medicare and did receive some Medicare reimbursement for doctors and prescriptions.
Well, I want to thank you all for coming to the presentation today. We have refreshments and cookies and some food in the back of the room, and we'll be moving the chairs away from that area. Also, if you're interested in Mr. Felos' book or tape, Barbara and Arlene will be over there to collect payment for that. And George would be happy to autograph the book if anyone's interested. Again, thanks so very much for coming. We really appreciate that.
Thank you.